2025, and we have a hearing with the Minister for Environment. So welcome. I'd like to draw everyone's attention to the following. This hearing will be filmed and streamed live, and the recording and transcript will be published afterwards on the States Assembly website. Please be reminded that all electronic devices should be switched to silent. So let's begin with introductions. My name is Deputy Hilary Jearn, and I'm the Chair of the Environment, Housing and Infrastructure Scrutiny Panel.
Deputy Tom Coles, Vice Chair.
Deputy Alex Curtis, Panel Member.
Deputy David Ward, Panel Member.
Constable David Johnson, Panel Member. Deputy Steve Luce, I'm Minister for Environment.
Constable Mike Jackson, Assistant Minister for the Environment.
Kelly Whitehead, Group Director for Regulation.
Lizette Jones, Head of Environment. Thank you. We have some online as well.
Online we have our States Vet, Susana Ramos.
Susana Ramos, States Vet.
And I'm expecting Head of Marine Resources, Francis Benier.
Yes, well, our questions are later in the session, so hopefully he'll join us before we get there, Minister. So we have tried to work out, because you have so many things that you are responsible for, how to get a lot of information out of you in these quarterly hearings. And so our first kind of section we want to do is a progress update section, and we'll try to condense them as short as possible, so we can get on to some kind of more specialised areas.
I'll try my best
so I hope that
keep things short and sweet.
Thank you very much, Minister. So I have that task of trying to keep these also short and sweet. So, Minister, you've previously stated in response to questions that you are reviewing the use and operation of the existing provisions to protect special trees and to regulate works, and that this will be included in the development of a clear process and policy for the protection of trees. When will this work begin on the development of this process and policy?
Well, trees is something, as you know, Chairman, that's a bit close to my heart, and I expressed a view very early on in my ministry that I wanted to do a lot more work with the trees. We had a proposition about protecting just about every tree on the island, which wasn't successful, and then I certainly was opposed to that. I thought that was a bit of a sledgehammer to crack a nut, but notwithstanding that, we do need to do more work. We have gone away and set up a tree advisory board with a panel, and we're adding some new members to that in the near future. Sam Ray Manor, Greening Foundation, officers from Climate Emergency and the Construction Council, adding to the people who are already on the board, which represent National Trust, Trees for Life, Farmers Union and an agricultural representative. We also have support from the Office of the Lieutenant Governor. We have spent the last 12 months getting ready, if you like, putting the preparation in place so that we can get on. And I've told officers I'm really determined to plant trees this autumn and winter. It's very, we get the season for planting trees disappears very quickly. And I am very keen to make sure that once we get into tree planting season, September time, that we're ready to go. We've done a lot of work on the preparation, and I can't say more than that, really. We have issued, we've got some guidelines as to how we want to move forward with those.
So is this tree advisory board mainly about planting trees rather than looking at protecting trees, just in the sense that we've had some quite high-profile cases recently about where through planning issues there is potentially knocking down a lot of trees, but there is also concern that there has been a bulldozing of a large area of trees, for example, in the Flickay area. And
Yes.
what would this tree advisory board do to help mitigate such a situation?
Well, I'd like to think they will come forward with suggestions about protection. Certainly there are a number of different ways of setting about that. I had considered, and I'm still considering, something which comes from the UK, which is, I believe it's called a trashing policy, whereby there would be a presumption that any site that you can't, well, I think in short what it means is you can't go out and just take every tree down on the site and then 6 months later apply for planning permission because the site is clear. And that's something I'd considered, but we certainly need to work harder. When I had the pleasure of being on the planning committee, and we'll remember a site at Kenneway, where we made a very big play for protecting a number of specimen trees on a particular site that was going to go for housing. And it was a great shock to me, not many months later, to find that all those trees had been taken down because the developer made some claim that the root structures were interfering with the building. And I would very much have been of the thought process that maybe we should have said, well, if they're interfering with the building, you better move the building rather than take the tree down. Because in this particular site, there were a very large number of trees, many of which were taken down and very few were left. And we were assured that those trees were going to stay in place. They did a large tree survey and it appears that it all accounted for nothing. So we have to do more.
Yes, and I think this is so would the Tree Advisory Board be the place to do that? Because this is the concern.
I want all things trees to be channeled through this Tree Advisory Board. They represent a really broad across the board from island community, and I want them to look at everything to do with trees. That's new forests, that's planting small areas in parts of fields which aren't used, looking at specimen trees, looking at how we can protect trees in the urban area, which are really important. I mean, that's one of the...
And would they be looking at the planning and building law and looking at that from that trees perspective? Because you were talking about it from within a planning perspective.
I don't know.
Pick that up. Yeah, the planning policy team is looking at the review of the listing legislation under the planning and building law. Work has commenced, starting with the review of the assessment criteria, and progress has been slightly slower than we had anticipated because we're focusing on the planning reform pieces. It's the same team doing both pieces of work, but of course the amenity value of trees is being considered as part of that process.
Thank you very much.
I mean, this is one of the other things. I'm trying to find the list. Oh, here we are. This is the one I wanted to say. So the things that the board are specifically looking at, there's 5 topics here. The right tree in the right place, establishing new woods, special trees, tree protection, and the championing of special trees. But something else we need to consider, I know we have what we call native Jersey trees, but it's clear that as climate changes, that certain trees will survive much better than some of our, what we would class as natives. And we're going to have to think about how we might move towards the encouraging the growing of different species of trees. I'm not an expert, so I couldn't say which ones, but I am aware that some of our traditional trees don't survive or won't survive well in the climate that we know is coming.
No,
I think if I may chip in, I mean, it's fair to say that macrocarpus will grow rapidly, but of course they tend to dominate the whole area, and I think tree selection is terribly important. I mean, evergreen oaks, a home oak is a native Jersey tree which grows like a weed, but of course they do provide serve a purpose as well. So the advice from arboricultural experts, I think, is quite important.
Yeah, thank you. Moving on. At our hearing in December last year, you stated that you and your Assistant Minister were looking forward to the first scheme of the designation of a conservation area in St Albans. What stage has this scheme reached?
Well, we're moving forward. It hasn't progressed quite as quickly as I would have liked, but we have done the first round of consultation and a paper is being prepared. I believe I'm trying to think now. I think I'm going to be signing something before the end of this year, which will move us forward in that. As we know, we're going to start with St Albans. So we've had initial meetings with people who live in the area. We've got the draft conservation area appraisal done, and we're doing a management plan, and then we're going to do a formal consultation, and the feedback from that will allow me to designate before the end of this year, I hope.
So would this, because the government website indicates that the appraisal and management plan is expected to be published for consultation in the first quarter of 2025. So you're saying that it now is coming more in quarter 3?
We've, as I said, we are coming to a conclusion. I am hoping to sign it this year, but things haven't moved quite as quickly with resources and stuff. We've got lots of other things to get on with. But we are making progress. As I said, we have got this draft conservation area appraisal underway, and the management plan's underway, and we have had meetings. The biggest challenge, I think, was always one of the big challenges was always going to be the red line around the area. And while it's quite easy to designate, I would suspect where the red line will be on the south end of St Albans, where where the town meets the sea, if you like. And as you go up the hill, I think that might be quite straightforward. Where the red line stops as you move further north is going to be an interesting. I mean, we have the Constable St Billard's here. Obviously, we know there's listed buildings on that seafront. How far do you get towards La Hull? I don't know.
There are natural breaks, but I don't think it will be a straight line, and I think there might be a little bit of subjectivity when it comes to deciding on the boundary. I think it's fair to say, and I have met with my constable's hat with our historic buildings advisor, who indicated the direction. Of course, it's quite difficult. We've got a mix of building, and I suppose what we're looking in planning terms is how new buildings might be created to fall into line with the tenets of the conservation area.
Do you see that this is going to be something that will be concluded before the end of the term? Is that also it will roll on into the next from this?
I'm expecting to sign the designation this year in 2025, and that's my expectation. I can't guarantee it, obviously, because if the paperwork's not done, I can't do that. But on the basis that I'm expected to sign it this year, if it doesn't happen this year, it will happen very early in 2026. And as and when we have time and resource, I would expect to move on from that point and go for further designations. I'm certainly, as a representative for St Martin and Grouvelle, I'd be very keen to see work done around Gorey Pier and the area below Gorey Castle on that area there. But I know there's other areas in St Helier, for example, and there may be other areas.
That will be for the future.
That will be for the future, yeah.
Thank you, Minister. So in answer to an oral question in February this year, you stated that a report would be tabled as soon as possible following a review of the guidance for residential space standards. When will this report be published?
In the very near future, with Deputy Coles, I have to say...
Before or after the summer?
Before the summer, let me say that. I may have put the officer responsible on the spot. If he's listening in from his holiday location, he will now be not having such a holiday. I have concluded site visits. I have done a large number of site visits to many different properties, older, brand new, and looked at all various options, and I am close to getting to a conclusion and publishing that.
Okay, thank you. And what changes have been noted by the Environment Department since the removal in February of the 3,000 square foot floor space limit on the development of new homes? Has there been any changes?
Certainly, I'm not aware of any changes. I don't know whether Kelly has any observations on that. I mean, I guess it might be a slightly tricky one, in as much as you'd almost have to interview the applicant to find out whether they've been considering that when they've put their application in.
I don't think that we have any real impact. We haven't noticed a significant amount of applications that have been submitted for large homes from memory, but maybe if there's one or two, but I would have to go back and have a look at that. But not a substantial impact, no.
Change. Okay, thank you.
When the applications come in front of me, or if there's a notable application, I'm informed. But I mean, I wouldn't have the detail at that point about the number of square feet involved or anything like that. So it's not something that comes across my desk unless it's a subject of an appeal.
Thank you. At our last quarterly hearing with you in March and in correspondence following the hearing, an outline timeline was provided for the review of the building bylaws. At that stage, officials were carrying out a high-level review of best practice throughout 2025. How has this work progressed, and have you started the stakeholder review that was anticipated for the spring of 2025?
Well, I'm going to hand this one over to Kelly because it's firmly in her specialist domain. But we are progressing. As you know, we delayed the work on energy certificates because we wanted to get bylaws done out of the door so that the energy certification work could reference the bylaws. How well are we progressing? I mean, I know we are, and I know I've had meetings with officers. Just trying to think of the latest timeline for that work. I
Yes,
know
we
lots
have.
on.
Yeah, absolutely. We have started our stakeholder engagement on building bylaws. We have split the work stream, as you know, into sort of 3 key areas. So the first area around safety, the second area around sort of net zero, and the third around standards. We have initiated the work stream 1, which is on safety, with engagements already this month, and we're targeting the stakeholder engagements for the net zero and the accessibility home standards starting in July to August. And the timeline is on track to have reviewed all 12 technical guidance documents by the end of this year.
Could I just ask on that briefly? Does that mean that any survey or information has gone out into the public yet for part 1, which is your review on safety? Because
Yep.
I do recall seeing a survey, but I can't find it anymore. I just wondered where you
Yes,
are in that process.
there's a-
Public, or are we doing it with selected stakeholders?
Yeah,
Because
it's-
bylaws are slightly, they're pretty technical.
They are. I do recall
Yes.
seeing a survey that was hosted, and it was published, and it included questions on the SER scheme, on fire rating, and other things. And I just wondered if that's still live or not.
It is still live because it's a selected stakeholder group. It was sent directly as a link to stakeholders because we're not going through a formal public consultation, and it's not appearing on the webpage of gov.je. But when, as a stakeholder, as an interested stakeholder, people being sent a link, and then that will open effectively a page on with the survey data.
Yeah, can I just ask a question? I mean, I'm obsessed with red tape and running a business myself. What's the impact on small businesses, on food outlets? What's going to be the impact of increasing this increasing regulation?
This is not an increase in regulation.
Right.
This is the revision of the building bylaws technical guidance on the structural safety and fire safety of how buildings are built and constructed. So this is not, this is a modernisation and bringing the technical guidance from 2012, 2014 up to best
Right,
practice
okay.
standards.
Does that mean retrofitting? Does that mean there'll be needs to retrofit?
It's not going to increase the amount of building applications that will be submitted. If you already require a building application under the
But if
planning
you
and
already-
building law,
okay.
the guidance and the standards to which you would need to build will be up to best practice, including fire safety.
Okay, so this is forward-looking rather than backward-looking.
Absolutely.
That's the point
So
I'm trying
it's
to make.
moving forward with
Yeah.
new standards.
Could I very briefly ask why it's not decided to put these surveys public? I appreciate that there is a set of stakeholders, but obviously targeting those in the industry may then give a skewed response, especially to the questions that I saw, which were about the suitability or success of the structural engineers registration scheme, where members of the public may have had a lot of experience with their engineer or with others, but they don't have a point of feedback on this. So I wonder, are you going to consider whether this is the right approach as you keep reviewing?
That's a... Sorry.
My own response would be that, yes, I suppose we could consider going to the public. The problem that I imagine we would have, that when it comes to talking about, you know, steel specification, insulation, thicknesses and stuff like that, fire safety, it's very specialist. And while few members of the public may well have some specialisms which would allow them to have an informed opinion, I would have thought it would be quite challenging for the public to understand some of these issues that we're dealing with when it comes to building bylaws.
I could add to that, Minister. Thank you. It was taken into account, so we looked at consultation and whether that would be public or targeted stakeholder. When you go to public consultation, it needs to be of public interest. The very specific technical information in the guidance documents, as the Minister said, will be about structural calculations. So we felt that that was industry specific, and that's why this targeted stakeholder will be very much about construction industry and those in the industry who have that technical knowledge to be able to make comments on that. That's not to say that we wouldn't welcome other comments, but it wouldn't be appropriate to go to a full public consultation because we're not asking the public broad general principle questions. We are amending the technical specifications of the guidance. So that's why it was a choice for two stakeholder rather than full
If you
public.
could share the questions from the first survey with the panel so we could assess that as well, that'd be helpful.
Thank you. And moving on, are draft regulations for the food law still on track for public consultation this summer, as suggested at our hearing with you in March?
Yes, food law is now, we're looking at just after, I believe we're looking at just after the new year now, aren't we? But we are moving forward. I think the important thing to stress about the food law work was that it came in a number of different parts, which I'm trying to remember. But certainly there's labelling, there's the way warnings are given about menus and allergies. But there's no point in having that and the management of the kitchen and the ordering of the food without the legislation in place to allow us to actually do something about it if somebody causes an infraction. So we are bringing everything at the same time. We could have brought it in stages. I couldn't see any point in doing that. So all the work, all the legislation will come at the same time.
Public consultation.
So, yes, I can answer the
sorry.
questions on the specific dates. Thank you, Minister. Just specifically in the food law, the areas are on allergens, on food hygiene standards and on licensing and registrations. So in terms of the law drafting, we are largely complete and on track to have draft regulations ready for consultation. We will begin the pre-consultation stakeholder engagement this month, so starting next week. We have 3 sessions with industry. That is, again, a pre-consultation with the stakeholders to get the views of the industry first. The summer window for public consultation will be end of July to August, and then we are looking at the revisions and hoping lodging before the end of the year.
Okay. Thank you for that, and that will help because, of course, we will be following closely on all of those issues. So jumping a little bit to another topic, Minister, I said this was fast moving.
That's fine, keep going.
The panel is aware that members of the public remain concerned about controls on dangerous dogs and the lack of changes being made to the Dogs Jersey law. Please can you update the panel on the status of amendments to the law and the timetable?
So as opposed to animal welfare, we're talking about dangerous dogs. Okay.
Yes.
This is something I've been aware of certainly since I came into office. Fortunately, my assistant ministers also chair the committee who have this under their remit. I've spoken to the vet. We've done some good work, but I have to say things haven't moved quite as quickly as I would have liked. But I did speak to people about it last week. Maybe the constable could give us an update. I believe we're always very close, but we're not quite there yet.
If I can just chip in, I mean, there's enthusiasm from obviously this department and the committee to progress this law, and the States Vets who's online might wish to comment on it. But the situation at the moment is basically it's with the law, with the legal drafters, it's I think it's got pushed back down the line because as a result of should we say higher election demands. But Suzanne might be able to comment
I
on
think
that.
you're discussing it this month, 14th to the 14th.
The connotables are at one on this. Yes, we are formally discussing it, taking it through, but there's no resistance to move it on, because I'm fully aware of the risks of the American bulldogs.
So in a way, the policy's there, everything's there, it just needs to be drafted, and therefore that's where the kind of bottleneck
Well, I mean, we've
is.
started the drafting. Because I say there's 12 months now that I've been saying I do not want an incident involving a dangerous dog on my watch as minister, and every day that goes by, I am increasingly concerned that something might happen. And we know we do have some animals which we would like to designate as dangerous dogs on this island. That number's not reducing. We have introduced some measures, and I see Susanna, our States Vet, is there. Maybe, Susanna, you'd like to comment a little bit about some of the dangerous dogs work that we've been doing?
Can do. So, as you said, the majority of dangerous dogs kind of conditions will be set up under the dogs law. What we introduced initially was a ban on imported dangerous dogs. So we assumed, we knew we didn't have a lot in the island, so we thought the easiest way was to stop anything else coming in. And we've informally approached all the dog owners that we are aware of with advisory conditions, because obviously with no law to support that, that's probably the best we can do. So then we working with the committee to support the drafting of, giving the technical expertise for the drafting of the amendments of the current dogs law, which is progressing. And again, it's being bolstered up between law drafters and ourselves at this moment in time. So the attention is on it, and it should progress quickly now. I would hope.
Okay, thank you, Susanna.
Thank you. Yes.
Yeah, just to clarify, the system as I mentioned it, the comitatus did not just the dangerous dogs, but the control of dogs generally, particularly professional dog walkers. Is guidance out there which I think honourable police don't regard as strong enough? Is intention to incorporate that in law, whether amendment to dogs law or is it something else?
I think there was, whilst I can't give you the detail, there was an intention to combine all these outstanding matters in the dog law change, and that will come to light on the 14th at our next council's meeting.
Okay, so we're contemplating bringing that in through the dogs law, which doesn't actually cover that at the moment.
Indeed, that was the thought, to try and lump it all together.
Okay, thank you. Thanks, Ed.
There's also animal welfare law, which we're going to come on to, and I think that I'm not sure that some of that might be part of that. But certainly when it comes to dogs specifically, I mean, I was conscious 10 years ago that we had a huge, I think it was something around a 20% increase in number of dogs in Jersey in a very short period of 2 or 3 years, as a consequence of the rescue centres in Spain and Portugal. Dogs coming to Jersey, so there was a large increase, and I think over COVID we've seen further, and there are a large number of dogs in Jersey, so it's not surprising that they give us issues occasionally.
Thank you, Minister, and we'll obviously be following that as well. And last from me, and something that we haven't asked you in a number of hearings, but we have followed up in letters, is around the carbon neutral roadmap. So we thought it's important to ask you a few follow-up questions, and you sent us a letter in April about the progress, and you indicated that there would be a briefing for the panel would be forthcoming following consultation with suppliers on legislation to implement a ban on fossil fuel boilers. What engagement has taken place, and when will you be in a position to move forward with this ban?
Well, I'm hoping, and brought Lizette with me today because she's the expert, but I'm hoping to be able to move forward with this fairly soon. And the reason I haven't done it thus far is that I'm still considering responses from industry. I'm still talking to people like Skills Jersey and others about how we increase the number of qualified people to do this work, because as you may remember, the reason I delayed from 2026 was purely because I was extremely worried that if people had to replace oil-fired carbon boilers with alternatives, that we didn't have enough technical knowledge or input on the island to do that work. So I delayed, and we're working with the industry. We've had a number of meetings. We certainly had a breakfast meeting with the construction industry quite recently, where we spoke about the implementation. The noise I'm getting from industry is, we don't mind so much when the date is, just get on and make the decision so we know when it's coming. And so I'm really conscious that I do have to make that decision. I'm also conscious that I want to be fair to everybody, and that if we're on one hand encouraging people down the electricity road, we're doing that because we don't want to burn carbon. There are alternatives with biofuels, biogas, and I want to make sure that people do have an option, because the important thing about replacing oil-fired carbon boilers is to cut emissions. It's not necessarily anything else other than reducing emissions. So I want to make sure that we've got some options in that area. But notwithstanding that,
so you will be bringing this date before, like, we will know this before the end of the political term. So
yes, absolutely. I am very conscious that it's in my gift to make this decision. I don't want to shirk my responsibilities, as much as this is a challenging decision to make. I definitely will be making a decision on boilers before the election, for sure.
And you talked about green skills and the importance of having enough skills in the island to be able to support this. Could you give us an update maybe on how you've worked also with the Better Business support package, whether there is within that support to the industry to help them specifically within this, to help them to support skills development within their companies?
Well, certainly I have had people asked to meet me, and I've asked them to come into the department who represented, well, not, they were the smaller business sector of this this whole area, and they expressed to me the challenges that they have within their small business, where there might be a team of 2 or 3, where they go into a house to quote, if you like, for an electric heating system, whether that be flow or the challenge for them is, do we have the expertise to design it, and do we have the expertise to specify?
But how are you communicating with the industry to say that there is this better business supports package?
Okay, Lizette, you fire away. I was just about to talk about the work we've done with JE, but you go on
Yes,
and say first.
Just specifically about the Better Business support package, last week I think it was, we ran an industry session with businesses, with the Jersey Association of Sustainability Practitioners, where we did a joint presentation with Jersey Business, where they talked about how the Better Business support package could be utilised for productivity projects that could include heating efficiency and heating transformation projects. And we are aware from our discussions with them that they have had a number of applications for the replacement of heating and cooking systems away from fossil fuels to more efficient, low carbon options that demonstrate that productivity increase.
Yeah, I mean, we have got, I think we've recently had one new applicant to qualify for the scheme for putting the systems in. We know we've got another company which is in the process of doing that. Mm-hmm. So we are making slow, but we are making progress. And most recently, I've spoken to Jersey Electricity about how we might develop schemes and use JE to support apprenticeships and training. It's been slightly just turned down a bit on the heating to, not going to progress quite as fast as we would like.
Understood. And final question from me, could you update the panel on the status of the net zero financing strategy work stream?
Oh, there's I could give you a very short answer, but
please, because we've...
it's work to be done. I've highlighted to council ministers very recently that net zero is a very expensive thing that we're going to need to fund. I've told them how much money we need roughly on an annual basis. They know how much I get on an annual basis at the moment. The two numbers are not close to each other. And the easy answer is to say this is something for the next government to address. And certainly, while that's pushing it down the road, phase 2, as you will know, 26 to 30, coincides deliberately with the next term of government. We're going to need funding for phase 2, and we're going to need funding for the much bigger scheme, which it started off as the £300 million scheme. I suspect it may be more than that.
So you're focusing, I know you said before you're focusing on phase 2 first, but will that be something that you will be putting towards the budget for this year?
I've already made indications that the amount of money coming into the Carbon Emergency Fund is not the amount of money I need to encourage people and to help and work with them to reduce carbon. And I have said that if I don't have enough money to help encourage, I may have to use the powers that I have to regulate in a way which misses out on the encouragement and goes from carrot to stick very quickly. And that's something I don't want to do, because I think by working with people and encouraging, we can work together to get to the same outcome. But I do need cash to do that. And the amount of cash coming into the fund is diminishing on an annual basis at the moment. I'm trying very hard to address that.
Okay, thank you, Minister. We'll probably want to have a briefing further on all these coming up.
Is there anything you wanted to add, Lizette?
I think the only thing back to that briefing is that we are preparing the annual progress report on the carbon neutral roadmap, and that might be a good opportunity to come back to the panel.
And very, very quickly, Climate Council, we're out for selecting people at the moment. They will have a short window to report early next year. Report comes in before the election. New government have that report to help inform their decision for moving forward.
Yes, and I'm working with you, Minister, on that. So thank you. I will now pass over to Deputy Coles.
Thank you. I have some questions regarding the rented dwelling licensing and enforcement of nuisance regulations. And these will tie in a little bit with the residential tenancy law amendments that have also been proposed. At our last hearing in March, you told the panel that the first annual report on the rented dwelling licensing scheme would be presented to the Assembly in June. Is that report close to being published?
It is very close to being published because I've seen it and approved it, and Kelly's going to tell us when it's going to be. It's Monday, is it?
You agreed it
I
Monday.
agree. I know I agreed it on Monday, but the question was about publishing.
So now we're just going to lodge it. So it's a report that needs to be lodged. So once we've done the lodgement, which is this week, then we'll be able to publish it. But yes,
Yeah.
it's a good report.
Yeah.
So
I mean, we started off 12 months ago. I think most people around the table thought that we might have 15,000 rented dwelling units kicking around in the island. At the moment, we're up to 18,170, which is a considerable increase over where we thought we might be. So, 36% of those units are social housing.
You've preempted a couple of my other questions, so that's wonderful. What feedback have you received on the second version of the Code of Practice, which was published back in April?
Well, the feedback I get comes pretty much entirely from the Jersey Landlords Association. We have, I think I can say, I was about to say bent over backwards, but we certainly worked very hard, and we've had a large number of meetings over the 12 months to come to an agreement with them about the wording and what's in, what's out. They'd still like to see an abridged version so that it's easier for their landlords to then reference a large document. We find that difficult because we want to make sure that they have all the information. They would very much always like to have specific examples, but we're always at pains to stress that every tenant, every property is unique, and it's very difficult to do that. So we tend to focus on generalisations. I don't know if you want to add anything to that, Kelly, but so feedback to the Minister on the Code of Conduct. No, I've had nothing very much recently, so I'm presuming that most people are fairly comfortable.
Since we published the second Code of Practice in April 25, we've had no direct feedback from anyone.
And how is this working in relation to your the officers that go out and inspect properties and interact with the landlords and tenants?
Really well. We've had 293 inspections so far, and we've been referring to the Code of Practice, since that's been quite a key piece, a document that helps explain where sort of why we're looking at specific hazards and things that are expected. We have identified a total of 177 hazards across those inspections, across 82 properties. And
I mean,
that's
the ones that
some
jump out on a regular basis, electrical, trip hazards, whether that's different levels and various ways that can happen, and damp, mould, cold. But I mean, we use something which we call the 4 E's. Kelly's mentioned explain. Engage is the first one we do. Then we encourage, and enforcement is very much the fourth of those four. And
The panel has it etched on in our minds, Minister.
okay, good. Well, I'm pleased.
So, but a question with that, because of course, how much of those properties that inspected, you said 293, of course you had that automatically, if properties hadn't registered by a certain date last year, they would then automatically go into that inspection pool. How many of those 293 have been because of issues raised, rather than it being the fact that they naturally fell because they were late with applying to the licence scheme?
So the transitional arrangements was until the end of August last year. So there was an automatic issuing of a licence with no inspection. However, that didn't stop us from reactively inspecting if there was a complaint raised. The rates on the reactive inspections are held separately, so we haven't linked the data in terms of whether those were pre-inspection pre-transitions or post-transitions. But post-transitions from September onwards has been the 293. They can be requested by landlords. So some landlords have contacted us and said, can you please come and inspect, so I know, I want a health check, essentially. So we've done that as well. Some of them have been risk-based. So that's based on the age of the property and whether we've had complaints in the past. There have been a range of reasons, not just specifically because they didn't fall within the transitional arrangements. So.
Could we just get a bit of a... You mentioned, Minister, that one key area was, for example, level changes or trip hazards. If that's coming up quite a lot, what are we seeing on the ground as to how these are either remediated or just acknowledged, given these kind of things are often structural and inherent in how a building is formed? I think a lot of concerns about the clarity that we heard as in that run-up, and no doubt your panel did earlier when you were chair, was about how do you then address some of these harder to address issues. So what's been the approach with the team in identifying hazards that have been inherently hard to address?
Well, the hazards are there. I mean, we know there's a big long list of things that officers need to look at when they go in, but we know that we have stats. I get stats on a weekly basis of the hazards that are identified, and as I said, damp and mould, electrical, and the trip hazards in various forms, change of levels and things like that certainly are always there at the top of the list, so that's something we're really conscious of. It does give us challenges, and you'll be only too aware listed buildings where banisters may not be quite high enough, or there's all sorts of things that we don't want to do inside the house, but officers are very conscious.
Yes, I can add, Minister. There's two types when we identify a hazard, as to whether it's a recommendation, and that's based on a risk-based assessment, or whether it's an unreasonable hazard that could be a threat. So that's when we would potentially place a non-standard condition on a licence for something to be fixed. And as the Minister said, there are many types of what we call falls, so risk as a fall, so between levels or at level. So again, it's very, very situational, and the officers do sort of work around things like frayed carpets, trailing wires, things like that could be quite easy to remedy. Things, or installing handrails to prevent falls, between the levels, or just removing items that pose a risk in terms of tripping. So there might be recommendations, but where we would see something very particularly structural, we would take that as a risk-based assessment as well. When we would be reasonable in our requirements for remedies.
But I'm sure you're conscious, some of the smallest changes in levels can be the ones that give us the biggest number of problems, because they're not big enough to physically see very easily. And I know we don't want to spend much time on it, but I think we know that older people who suffer from falls and breaks of bones and stuff, that is a really major event for them, a 78-year-old falling and breaking a bone. And so it's really incumbent upon us to try to outline these hazards, do what we can, identify them, and make sure people are aware of them, so people don't fall over.
As the scheme is still new, it's like you say, it's still within its first year, and these guidelines keep coming out. You say you've got the 177 hazards. How many of them have got above 2 E's in your 4 E's?
I'm not aware that we've got to enforcement.
We have not reached the 4th E. So we are between the 2nd and 3rd E. Yes, we have managed to, and sort of persuasive compliance and sort of encourage compliance. So we have seen compliance with the non-standard conditions on the licences, and to date we have not had to refer anything to the law officers for a case file.
Yeah, and I don't know if it's the next question, I'm also not conscious, and I presume it goes on from this, not conscious of any properties that we visited where we've made an immediate enforcement notice that said,
we've not
no,
seen
you can't stay here, you have to move immediately, so
no.
that's good.
Good. Could you outline your understanding of how, if at all, there will be any alignment and interplay between the rented dwelling licence scheme inspections and nuisance complaints under the proposed amended laws for the residential tenancies?
Well, it will be officers from the same department. It all comes under regulation. It would be the same officers that would go out, I imagine, to do both of those. We've always stated that where possible, and in order to reduce red tape and time and effort, and to avoid duplication, where possible, we would like officers to do more in one visit. Certainly that's the case with food licensing, where we're going to be in a position for officers to go in to do stuff they would done historically in other areas and then do food licensing.
I think just in terms of the between the nuisance, the rented dwelling licensing is a separate piece of legislation to the proposed and the existing residential tenancy. So whilst it would be the same officers who could advise on both, they are two separate pieces of legislation. The role of the officers would be to issue guidance and assist landlords in interpreting and evidencing sort of nuisance breaches. And support the development of model tenancy clauses for clarity and consistency and things like that. Provide training and procedural updates to help sort of triage the complaints. So that would be kind of the role that the officers would take. Is that correct?
Can we just drill into this further? Because the Minister, your example was we want to be productive. And I think one thing the Scrutiny panel has been asking about is, well, if the officers who have an obligation in some ways to inspect properties under one law attend for a different purpose. So an officer comes to inspect a site because the landlord has requested support about a nuisance, and the officer arrives and sees a trip hazard. How do these two laws under one team interplay? Does the officer have a duty to record a hazard when they're on site? Do they have to keep a kind of a barrier between their two legislative functions?
That's one for you, because that's very specific, but it does raise a good point. I imagine it's to do with training qualifications. But
Yes, so we, our officers, you are correct. The officers are there and have a range of legislation. So yes, they would be, when they're visiting, making a note of all of the issues that they see. They would be under duty to alert if there was a hazard identified under minimum standards if they were there to support for residential tenancy. What is really important is that the officers are very clear what the purpose of the visit is for, and that if there would be a follow-up relating to, say, for example, minimum standards. Very similar, as the Minister had mentioned, we have officers who might go in and, as Deputy Wall mentions, into a premise that it might be for food and hygiene inspections, it could be for ticketing and price setting, it could be for a range of weights and measures and things like that. So we try to bring the site visits as we can collectively together, so you don't have multiple inspections. But it's, as long as we're very clear on what the legislation is that we're looking at and what the follow-ups are.
Yeah, can I just go further? I mean, I'm concerned that your officers might be involved when it's really a domestic dispute, landlord and tenant. I mean, if there's a health aspect, obviously it is your department, but do you see that as a danger, that if the landlord, for instance, if there's a regular breach of at least not keeping the garden tidy, but would you counter us a visit for a complaint of that nature to visit?
We would bring together the complaints as one as we can. So it could be a complaint for, we've had situations where the complaints are breaches for planning legislation as well as for nuisance or for a variety. So we have an obligation under the 39 laws that we do regulate. So it would be unreasonable for us to turn away from one legislation to another piece. But when we are on site, as long as we're clear with the individual, if there are breaches identified, the follow-up would be through the different teams, the different officers for the different legislation.
I think
But
getting
the
back
site
to
visits would be
statutory
combined.
nuisance, because Deputy Curtis did mention, I mean, it would only be the start of an investigation, because statutory nuisance is not something you can decide on a single visit. It would be a number of different visits.
Deputy Cole's probably going to touch more on that area.
Yeah, literally the next question area on this.
Yeah, just say one question. Sorry, did I hear you right? You said you've got to regulate 39 laws.
Yes.
Wow. Okay, that's a lot of red tape.
I mean, if you extrapolate that, what you don't want as a business owner is an officer coming on 39 consecutive days doing
I get that.
individual law.
I find it
I'm
extraordinary.
not sure we can do
laws.
39 with one officer on one day, but we certainly want to get down to as few visits as possible.
Okay.
I think we carry on with Deputy Coles.
So we're not sort of talking about the statutory nuisance, but we've got in the RTL the definition of serious nuisance. and whether or not that is clear enough to be able to enable a proportionate response and enforcement. So what do you consider this definition of serious nuisance to be?
I can.
Yeah,
respond
and you
this
want
one
to go? I
as
mean, I
well.
was going to talk about common
think
nuisance. Is that the same thing?
Civil nuisance or serious nuisance, it is subject to judicial interpretation and enforcement through the courts, so there would need to be a sort of case precedent. We would, under the proposals, the directorate or the officers wouldn't have sort of the authority to determine whether the nuisance has occurred or enough to compel an eviction, but that would need to be supported by the legal process. So that the landlords and tenants are equipped with the necessary tools to understand those new provisions. And clearly, as you understand, it's a proposed legislation as well. So there's things to go.
In that sense, and you're saying that it needs interpretations and case precedent to be able to do it. So at the moment, we don't necessarily have that. But is there a situation that you could see where you've got a dispute between, obviously this will be a dispute between a tenant and a landlord, who the landlord is showing that there is evidence from a serious nuisance perspective to be able to ask to serve a notice to a tenant is disputing.
Fusion there between the two.
I think as well, it'd be difficult to assume what the courts would do in the situation until we're actually in that situation, which is also a little bit difficult to answer at this point in time. We can look to UK case law and the UK situation, but it is slightly different as well. So it is difficult at this point to sort of make an assessment where that might lead to for Jersey courts.
I mean, I think we are conscious statutory nuisance is quite a high hurdle to get over, and there's a bit of a gap in Jersey law that needs filling to make it a little bit easier for everybody, but quite where that is, I'm not quite sure.
Okay. I did have a couple of few, but you kind of alluded that until the residential tenancy law amendments are either accepted, that you've got a lot of work to do after that. So I suppose it would still come down, my final question in this particular area then is more about whether you feel that you'll have the team to, one, be part of that engagement to flow those amendments through to how they'll be enforced, and then also pick up any extra work that comes your way if this law then becomes enacted.
Okay, I'm gonna start off on this one because we have on one hand people saying there's too much red tape, we've got to reduce the amount of regulation, and yet we continue to bring to the Assembly new laws and new rules, which then mean that Kelly and her regulation team, who are already hard pressed to cope with what they can do, and we have a number of things coming down the pipeline, all of which are going to result in additional work for regulation. The one we're talking about here is one where we're talking about some work with consumer credit, which would be another. We're talking about, I'm trying to think of some of the others.
Heritage law.
Sorry?
The heritage law.
Yes, yep, all sorts of things where, and I'm trying to think, the heritage law was the, I'm trying to think of the word, we discover a whole load of artefacts under the, yeah. There's all sorts of things which are dropping in Kelly's lap and her officers' laps to do, and her team are, given the amount of work they're being asked to do, my team are under-resourced financially and in numbers really, and this would be another example. People are amazed how much variation and regulation we have to cope with, and it's the same team that get the work.
And Minister, how are you resolving this? Because we heard from the Minister for Housing that that they have been working closely with your team, and that they think that there is not, that this won't be an additional burden because they are doing this within their remit already.
Not sure
and so we
that's
heard
the
that
message I'm getting from my team. I think that
I'm talking to the Minister for Housing to ensure that
I haven't had a talk with the Minister for Housing yet, but I've certainly spoken to my team about the potential, and I've asked them a number of questions, and I have some concerns that there's more work to do.
I could clarify as well and agree with the Minister for Environment. I think there's probably a point of distinction in terms of the additional work to enforce the proposed residential tenancy law, we already enforce the existing residential tenancy law. So in terms of that element, that is not envisaged to add more work to the team. I think the Minister for Environment is referring to what we would define as sort of operational implementation. So once a law is put into place, it actually, like you were saying for residential tenancy, there's policy documents and codes of practice and things that need to be put into place, communications and, communication plan. And I think that is project work
but there is a big change with the law, which is that now landlords will, when they want to serve notice, they will have to give that a reason, and one of them is serious nuisance, and under that serious nuisance they need to then have the evidence to provide that, because a tenant has their right to push back on that notice. And the law specifically says that there needs to be, your team needs to be the ones who collect that evidence, and there's a specific process on that to be able to have that evidence. So that is a new bit of the law, and will your team be able to be, that has the resources to do that, to support landlords in developing nuisance. And of course it's repeated nuisance, so it's not just one time, it will be continued, it has to be 24 hours a day potentially. I mean, it could be, how will you be?
It is
Can
different.
I answer the political
Yes,
aspect? If this is going to come in and those requirements that you've just stated, Chair, fall into the department, if things stay the same within the department, we will have to reprioritise work, so that some things won't. We do not have the capacity to continue to just add more work to the team, which are already struggling, coping with all the work they have to do. So I want to be absolutely clear. This sort of additional work would require, if we were going to do it, would require something else dropping off the list. My officers just cannot, they do not have any more time, or,
But Minister, we've heard from the Minister for Housing when we brought this, because we saw your letter that you sent to us as part of our scrutiny review into this, the amendments, and the message was very clear, which is what you're also reiterating now. And we brought that concerns to the Minister for Housing, and it was the Minister for Housing said that they are working with you and your officers to ensure that there isn't this extra burden. So I'm just a bit confused, because we just want to make sure that there is this.
I'm not sure how the Housing Minister feels that he knows there's enough capacity inside the resource.
The Minister for Environment is absolutely correct. There is significant pressures on the team. With regards to the sort of civil nuisance, I think the issue is we don't know currently that volume might create. It is for the courts to establish the nuisance, and like I said, itself. So, the parts of the other elements of the legislation that have changed, it might increase queries to the team, but at this stage it's a little bit difficult to predict. So I think that's where, we were saying that it is definitely within the sort of skill set of the team to be able to when we know more about volumes, that's I think where we need to consider the resource implications. But I think both ministers are correct in the elements that they were sort of relaying to you.
The challenge for me and my team and Kelly is that different ministers come up with different pieces of legislation. They all end up in the regulation department for enforcement, and it's fine coming up with all these rules and regulations, but it's only one team that has to go out there and do the work. And we sat in a meeting not dissimilar to this yesterday, where another minister saying, well, this is really important, and we didn't disagree. It's really important work that needs to be done. The challenge is, when it comes to regulating these new rules, it's the regulation team that have to do it, and they're already at full capacity.
I've got some questions. Dave, first of all,
just very
Deputy
quickly,
David, and then...
So my question, and the ultimate question surely has to be, are there any mechanisms which identify the cost-benefit analysis of this work? I mean, are we just simply bringing in more and more red tape, which is costing us more and more as a society we talk about sledgehammers and cracking nuts. Is this the danger we're ending up in? We're so obsessed with regulating so much stuff that we actually end up losing the why. Why are we regulating? Why are we doing this?
It's a challenge, and certainly it comes down to, people challenge me. We want less red tape. We want to regulate less. and that's fine, and I can see what they're saying, until a point where they, you know, unless you are individually affected by some sort of consumer credit issue, where there's no recourse to anybody or something else, you know, a whole number of different...
To come back to my point, but come back to my point
then you want regulation.
Yeah, you do.
People don't want regulation until they need it, and then when they do need it, they really want it, and they want lots of it.
But we have no mechanism to measure the impact of red tape.
So there is
Cost.
A way that I like to describe regulation is a way of a sort of big R regulation and little R regulation. The big R regulation is the laws, the 39 pieces of laws, and the new laws. Every single law has a very, very valid, legitimate, and public protection basis in which to bring forward. I challenge anyone who would say, look at any of those pieces of legislation and say we do not need that big R. But it's how you regulate, and that's the little R regulation, and that's the 4 E's. It's risk-based, it's intelligence-led, it's using the officers the best time to actually find where is the harm and where is the public protection. And so I would challenge the sort of concept of the red tape element. I do think that the laws are there and they are very powerful, and it is how we do that, the little R of regulation, that's going to make the difference in the community to enable businesses to thrive, but also to protect the public, the safety and the environment at the same time. And I think that's sort of where we've been focusing our attention, is not so much on the black and white big R laws, but actually on the little R and at how officers interpreting those laws, how we're risk assessing them, how we bring forward voluntary compliance and working with the community. Rules are there. Are they always rules? Rules are there in place because people want the rules in place, but it's how we motivate people to comply and do it in such a way that doesn't feel like red tape. And I think that's...
And of course, laws, and look, officers don't introduce laws.
No.
States Assembly introduces laws.
I think Conatab and then...
Yes, I don't want to overdwell on the matter, but to go back to the point raised by the Chair, that the draft law about the residential letties law as drafted does require that evidence of repeated breach has to be accompanied by statements of officers to that effect. Now, are you in fact saying that whereas previously it was just the law of evidence which could be done by other people, are you saying that as matters stand, you wouldn't be able to comply with that unless you were given additional resources?
No. What I'm saying is it's a slightly subtly different answer, is if we were given this law and said you must implement that, and we had to, something else in the department would have to fall off the bottom of the list, because we can't do everything.
Well, that clarifies
Thank you.
things.
I think Deputy Coles will probably go into a bit more of what you were actually saying.
Yeah, I think it's going to cover a little bit more of the sort of the big and the little R, because this area is going to be on the complaints panel's finding regarding to Northern Leaf. Before we go too far on that, Minister, we are aware that you are in the process of that response to that complaint, and therefore we appreciate that you may not be able to offer full and detailed answers to that case specifically, but we're talking the ability of around the more broader sense of the complaint. So we start off with, can you first address the finding that the existing statutory nuisance laws, Jersey 1999, was weak and did not provide adequate thresholds by which complaints could be measured? How far do you agree with this view?
Well, there's, and I'm sure Kelly will give us the detail for what we call the Clapham Omnibus test, which is, you have to, unfortunately, in many of these statutory nuisance cases, and I empathise with people who are affected for whatever reason. There's a number of ways that you can be affected, but certain individuals, for some reason, and we don't deny that they're not being affected, are affected by things. But in order to prove statutory nuisance, if I've got this wrong, you have to take a general test. How would a member of the general public over a generalised period of time be affected by it? Is it regular enough? Would a normal person feel affected by this? And as unfortunate as it is, certain people get affected by things where other people don't. And it's really, really difficult to prove statutory nuisance in those cases. So I'm not saying that things don't exist, but actually proving statutory nuisance is quite complicated, and it's a very high bar to get over. And we spoke about, the gap in Jersey legislation for common law and stuff like that, and we're talking about serious nuisance and other ways of describing it.
I would add that we would disagree that statutory nuisance law was weak in terms of the legislation to meet a criminal level of nuisance. It is as the UK would define it. So for that level, it achieves what the purpose of the law is set out to achieve. Potentially where there is a legislative gap is something similar to we were just talking about RTL, which is around common law nuisance. So common law nuisance is a civil level. So the closest equivalent in Jersey is the voisinage law, which is the civil law. So we have sort of previously discussed that, I believe, in the States. So that would potentially be where the gap would be. It is not to say that the current criminal level threshold of statutory nuisance is not fit for purpose. It is. It is a very high bar of threshold for evidence, which is where people are becoming frustrated, because actually some of the disturbance and nuisance is at a civil level, not at a criminal statutory level. But there are two types of pieces of the purpose for that type of law. So yes, we would identify, and I think the Minister has identified, that it would be nice to bring forward some amendments and changes to the statutory nuisance to introduce that concept to adequately cover the civil disturbance. That is something that is in the UK legislation, but in this term of government, it's not been a priority for the very valid reason of all the other exciting priorities.
Yeah. Thank you for that answer. That covers quite a number of our additional questions. What steps is the department making to improve handling of complaints in line with the findings, particularly in relation to poor engagement with complainants and the delays in making abated orders outlined in the report?
Well, it's difficult to know quite where to start, but I would imagine that the vast majority of complaints about the way the state works ends up with coming through the regulation department, because we're the people that go out and decide. We've been accused recently of acting unlawfully and being unjust, and I'd just like to say for the record that I absolutely refute that. I stand 100% behind all my officers in the department. They are hard-working. They do things with the best intentions. They are looking after the interests of the public, and I accept that occasionally people will be unhappy with them, but they really do try hard. We have a very strict complaints procedure within the department, a number of stages we go through internally before it then goes to potentially a complaints board. And I stand behind the process. I mean, we respond at every opportunity. We have strict rules about responding to emails, responding to complaints. We go out on site as often as we can. But it is not always possible for an officer to pick up for the department to receive a phone call and for an officer to respond immediately. We just can't do everything at all times. Certainly, and I don't particularly want to talk too much specifically about Northern Leaf, but I can say that a large number of officers have spent an inordinate amount of time on this case over a number of years. And I don't know if you want to say more than that, Kelly.
As the Deputy mentioned, it's difficult to be able to discuss at this point in time because the Minister is bringing forward his response to the Assembly. But thank you for your support of officers, Minister.
Is there possibly a conflict between how the planning process works and when it comes down to enforcement as well? Because we see on a number of different sites where a compliance order may be issued and an action may have to cease because it's not compliant with planning. But then we have other situations where work is still allowed to carry on even though a compliance order has been served, and also you see times where an applicant will put in a new application for a site even once enforcement notice has been issued.
As challenging as it is, it's always important that both sides of any argument are given a fair crack of the whip, and we try always to make sure that happens. Some people accuse us, well, why haven't you shut this business down? Why haven't you done more here? But in all cases, there's a process to go through, and it may well be that some people find that challenging, and I certainly take your views on board. We know now, or we've always known since we introduced a new appeals process, there's a number you can go to. You have an officer, you can go to committee, as you well know, you can have an appeal, and even then you can carry on through a process which can end up in 18 months, 2 years. It takes a long time. Even when we get to the point of enforcement, there's appeals on enforcement. We know there's some confusion over first-party appeals and third-party appeals, which we're going to resolve. But I do have empathy with the people who feel frustrated about the length of the process. It's a process that's been put in place to try to be fair and make sure that we do everything properly. At the end of the day, if we really get to the end of this and it ends up in the on the Attorney General's desk, he then has to then make a case if there's a public interest. And when we get to court, we then also, if we go to court, we've then got to be assured that the judge is going to look at all the work that the department have done and made sure.
And the big R of all these pieces of legislation is essentially identifying the evidence. If an offence is created, serving a notice. If the notice is not complied with, collecting the evidence of that non-compliance, taking that forward to a potential prosecution, which rests, as I said, with the law officers and the Attorney General to determine whether or not it's in the public's interest to take forward that case. That goes forward to the courts. The courts then make a judgment on that, and potentially the offence under some of these pieces of legislation is a fine. So what is the expectation on the department to physically change? That is the process under the law, and the powers that we have is to serve notices, collect evidence, find non-compliance, serve notices, pass it to the courts. Courts could potentially issue fines. And ultimately, and generally speaking, not specifically, but generally speaking, there are, people have rights under the law to appeal. They have rights to judicial review, and all of those things are legitimate judicially. So again, it's what is expected of our officers to make change. We do that through the law.
I would add, that this encouragement to try to resolve issues between sides is something that we always do. And I mean, most recently, I was in a public meeting at St Bernard's Parish Hall to talk about PFAS, and people criticised me. Oh, why are you not sort of going after Jersey Water?
We're just about to ask questions on PFAS, so maybe
I could finish and then
then hand over dirty war, so we can see.
Just give one last question on that. So, because you mentioned about streamlining for early resolution, do you, as Minister, then see any value in a public services ombudsman?
I think, I'm not going to pass too many comments on this because obviously I've got a response to come, but I think as we move forward, the case for a public services ombudsman is probably being made more and more and better and better. Yes.
Thank you, Minister. And coming back to PFAS, so you may be able to...
So here we go with the PFAS, all the fun subjects. We'll turn now to a series of questions on PFAS. Following the publication of the independent survey by Arcadis, please can you detail the next steps for the hydrological PFAS steering group and the delivery of a PFAS remediation strategy?
Well, it fits in beautifully with the question I was just answering. I was talking about encouragement, and certainly we've had Arcadis, the results have come out. The area affected by contamination of the airport has broadened a little bit. There's a couple of other areas which have been included now. And some people might say, right, Minister, you've got the regulation, you've got the power. Are you going after the airports? Are you going after Jersey Water? And I'm saying no. What I've done is I've formed the steering group, and we are going to work with ports. We're going to work with Jersey Water to try to resolve this amicably. We're going to work together. And when people criticise me, I say, well, this method of working is going to hopefully result in things happening much faster than if I start getting a big stick out and saying we're going to go to court, because that is would involve a huge amount of officer time and effort, preparing papers, and then, we'd have months, if not years, of nothing happening. So what we've done was we've sat down around the table, we're meeting monthly, and we're addressing, I want to call it the low-hanging fruit. We're going to do the easy bits first. So we know there's certain areas of the airport where the PFAS is escaping in runoff. It's in surface water, and we feel we can get somewhere with that before we get to the more complicated and much more time-consuming area of groundwater, which is to the west of the airport.
I would probably add, Minister, that we're also selecting the remediation strategy elements that have the greatest impact. So the ones that, so for example, the surface runoff, the ones we're tackling first, will have the most significant impact. Where some of
didn't
the
explain low-hanging fruit properly. This is what it means. But just before Kelly steps in, I just want to go back and say that one of the immediate things we're doing is a lot more testing. The Arcadis reports identified a lot more testing is required, and the department are getting on with
We're doing a full testing programme, additional survey and monitoring. We have contacted residents here in the expanded plume area, and also just I say that Ports Jersey and Jersey Water are fully engaged with the steering group in the process, and are very willing to work collaboratively with government to come to a resolution for the community.
Okay, thanks. I mean, I think you've covered about 3 or 4 of these questions. So the next one is, do you know how close Ports of Jersey is to finding acceptable outcome with the owners of the 2 properties in the plume area which still rely on borehole water?
I could respond to that, Minister, if that's okay. Because there are only 2 properties, it would be inappropriate for us to comment on particular circumstances. They would be identifiable.
Okay, thank you.
But we are working with
You're
them.
working with them, that's fine. Okay, so what details are you able to provide at this stage on the appraisal of potential water treatment options for PFAS undertaken by Jersey Water to see which are the most likely to meet new water quality regulations for the island?
Well, Jersey Water, I charged them with going away to investigate the options. Certainly the PFAS panel are coming back to report to us in the very near future on all things water. Their report concentrates on environmental aspects, but we've asked them if they could do the water part of the environment sooner, so that I believe in August we're going to have the report from the panel, and they will, in that report, do 2 things for me, which one will hopefully be to identify a level which they think would be appropriate for me to set moving forward, and one they might recommend, and they're also going to give me an answer on what they think might be the most appropriate way to treat water in order to not only get to that level, but for moving into the future. Obviously, there will be a number of well-known ways of doing carbon activated granular desalination, nanofiltration, ion exchange. They're all on the table, and the panel are going to report back on what they think is they're going to recommend where they think I should move forward. That will also work in with Jersey Waters, where they're at the moment coming quite close to the conclusion of a 5-year strategy document, which will also address water moving forward. Between the 3 sides, I'm sure we're going to come to an agreement and move forward.
Okay, thank you. I think we move on to animal welfare and Constable.
Yes, thank you, and just give the Minister a rest. Please could you confirm that it is your intention to lodge the new animal welfare law prior to the summer recess with a debate date of September this year?
Yes, well, Susanna's here and she's going to talk to us. Updates to the animal welfare law are very overdue. Our law is a 2004 law. It was based on what was in the UK at the time, which in turn was based on something in 1911. Very soon after we updated our laws, the UK then updated theirs. So they've been ahead of us for a large period of time. There's a number of things that we're doing, but Susanna, do you want to run through the various headlines, mutilations and bits and pieces, please?
And the timeline as well, if that's the original question.
Yeah, can do. So yeah, as the Minister said, our animal welfare law was quite old and not fit for purpose anymore. So the idea of the new law is to become more proactive and to allow us to act when there is a strong belief and strong suspicion that of suffering is or will be occurring. And the idea as well is to give us a little bit more power in terms of investigation, any situations where an inspector believe there's suffering occurring, and will give us the possibility of serving notices for breaches that are kind of more technical. It will also allow the Minister to do certain orders, to allow for change whenever that is required, and only when it's supported by scientific advice. And then we'll obviously look at the orders will look at things like mutilations, welfare at time of killing, licensing, prohibited procedures, that type of controls that are already existing in our current law. But the idea is that we have an animal welfare law that is the umbrella, and then we have orders that are more specific to which, we can go in more detail for each subject area if that makes sense.
So we're out for consultation this month, and that will finish before, I think it's a 3-week consultation, Susanna?
Yes, so 3-week consultation so consultation started on the 17th of June, and we'll finish on the 8th of July, and then we will have a briefing with you after that to discuss. So that's the plan.
And is it the plan to debate it in September, to bring it to the Assembly to be debated in September or later?
I think
might be I think it's a little bit later than that. I think it'll be October or November.
Okay, thank you.
But I might just add there's 2 really important things there for us. The first one is the taking possession of animals in distress, which is really important. And as Susanna's mentioned, the ability for officers to access property if they believe animals are in distress. So that's some major changes, but really important.
Can I just ask on that then, because also we've mentioned about officer time and team and resources. Are you going to be adequately resourced to bring these changes
That's
forward?
a question for Susanna, but obviously we have at the moment we're right up to speed with our vets. We had a fantastic vet team at the Howe Davis Farm, fronted up by Susanna and her 2 assistant vets and a team behind her, so I'm very confident. We've got the resources to do this, Susanna?
I think so. I think the difference is that, we do a lot of, we already do a lot of proactive work, and I think the law will just give us a bit more substance to be able to do better what we currently do. And if the legislation is clearly, you can actually save time potentially. So if it's clear cut what you want to do, so I'm confident the new law and the new orders will help us do our job better. Time will say if we may need more people or not. We probably wouldn't like to commit to an answer to that just now.
Well, you answered all the questions I had there. Thank you. Just one more, really. What, if any, powers are conferred on the JSPCA to take neglected animals into their care and to protect the welfare of animals which are not being cared for properly? Is there any delegated power to them?
I'm not sure if there are, but certainly Susanna and I went to the JSPCA. We've been in the last 10 days, had a really good meeting with them. We haven't signed anything, but there's certainly a commitment from myself, from the Vets Department and from the JSPCA themselves. We're going to work together a lot more. We have recently reached an agreement with them about a quarantine facility for animals that come in that need to be quarantined. We're looking at all sorts of areas where we could work closer together, and there's a real commitment. I think we discussed their officers having powers. I don't think we're there at the moment, but that's something we agreed we'd work on, isn't it?
No. So the current welfare legislation already allows for delegated powers for other people other than us, as long as they're correctly trained and authorized by ourselves to do so, which is a power that GSPCA doesn't have at the moment. And I think the new law will have the same possibility that others could be appointed as inspectors to work under the animal welfare law if we think that's appropriate and they have the adequate training. I don't think GSPCA is there at the moment. I don't think they want to do it yet. I think there is discussions that potentially can be something that we can work together towards in the future.
And do you have any numbers on the cases of neglect? So, like, understanding kind of what this law will.
Yeah, we have. I have the numbers in front of me. I can provide you later in writing if you wish. We have the numbers of cases that were dealt directly by us. How many by species. And what the conclusion is. There's certainly the majority of complaints and issues we have regarding animal welfare is related to dogs, then cats, and I think then livestock. Just a rough idea how it works. And the numbers for a place like us, the number of complaints are significant. The number of actually proved suffering, are really, really small. So, there's a big, there's a big disparity between what comes to us and what actually is constituting, a massive issue or indeed suffering.
Thank you.
Sorry, leading on that, can you give an indication of how many prosecutions you carried out over the last 12 months?
Since I'm in, we have myself. Our team has not prosecuted anyone in the last 2 years. And if I may say, I think we shouldn't measure the success of animal welfare by the number of prosecutions. It's actually the opposite. If we get someone to prosecution, it's because we all collectively fail in protecting the welfare of that animal. So if I may say, I don't think that's the way we should measure animal welfare.
Thank you very much. Deputy Curtis.
So, Minister, we're now going to spend a bit of time talking about the planning reform and the Bridging Island Plan implementation. And starting with the Industry Partnership Board, it's the panel's understanding that an annual report of the Industry Partnership Board was due to be published in May this year. Could you confirm, has this been published? And if not, what's the status of it?
Well, I'm not sure about that, but all I can say is I attended the Industry Partnership Board last week. We had a really good meeting for a couple of hours. I don't remember a discussion about an annual report,
Yes,
but I may have missed it.
It is in draft. We are delayed in publishing. It's not yet published, but it is in draft with the Industry Partnership Board because obviously it is the members' report. So once the members are satisfied with the report, ready for publication, it will come to the Minister for his agreement before we publish. But it is in draft with the Industry Partnership Board.
Okay. Do you know when they next meet and whether that's obviously on their agenda?
Well, we started off thinking about meeting 6 monthly, quarterly, but we've increased the frequency at the request of the board. And I think the next one's probably going to be beginning
in the
of
next
September.
couple of weeks, the board in the next couple of weeks will have
Really?
the preparation of the report and then
I've
to be
got the
presented to
frequency
the
wrong.
Minister. 29th of July is the next one.
29th of July. And that's their meeting, as I think Jim McKinnon noted in his report, bi-monthly still?
Correct, yeah,
And that's
2 months.
going to continue as it is?
2 monthly, yeah.
Okay. Do the Industry Partnership Board's meetings have minutes taken with them? And is that something that's currently published?
Rather than minutes, not verbatim minutes, but sort of actions, they do minute potentially or sort of raise with the Minister any sort of concerns that they're having or sort of feedback from the industry. It's not currently published.
It's not currently published. Okay. Thank you. And last time we spoke, we talked about the membership of the Industry Partnership Board and that rotating. Is there any update on the current membership or planned changes to the membership of the Industry Partnership Board?
I'm not trying to think who was there. There were some new faces that I hadn't seen before. I know it's a number of months. I can't answer that question. Kelly, you got any?
So I think the rotation was at the discretion of the industry boards, obviously as members no longer want to sit on the board, but generally it was, I think annually, they would look at reviewing the membership. It's also a matter of interest, isn't it, to have people to volunteer their time.
It is. And perhaps last question on the board. No doubt the annual report will cover the last 12 months,
Yeah.
but Minister, from your perspective, I don't know, for the last one you attended, what are the key themes either you've seen in attendance or that have kind of percolated up to you that the board is feeding back, kind of the hottest topics that are occurring in train? Because, of course, reform is constant, so what you're hearing now will be different to what you heard a year ago.
I certainly raised the question of design, and we spent quite a bit of time talking about design. A week or 10 days ago, I said I thought design, interior and exterior, was important. And I challenged those around the table, especially the architects, to work harder on design. I said,
The quantity of information required for the submission of an application, Minister. Also the promotion of the benefits of pre-application advice in obtaining successful permissions. And I think the board also said there was a noticeable proactive engagement between agents and officers. And I would also like the opportunity to mention that we had a recognition in the team, the Royal Town Planning Institute Southwest Award for Excellence for our Head of Development and Land, Andrew Marks, and Tracy Ingle from the Cabinet Office, and also the Marine Spatial Plan. So I think Andrew and Tracy's recognition was that contribution of improving planning services and reform.
Yeah, certainly I started the meeting with congratulations to Andrew in front. I wanted to make sure that I publicly said that to the board. We did talk about the amount of red tape or the amount of parts to an application, boxes you have to tick before you can get your application verified, and we have spoken recently about how some pieces of information that we require up front might be put back and actually come as part of an approval, put it under condition, but we have arguments around the House of whether that's pluses and minuses of that. But pre-app advice is going well, and the people around the table are appreciating that pre-app advice actually means something. So they're engaging, they're encouraging their sectors of the industry to engage. And I have to say that the Industry Partnership Board, I think, has been one of the many successes of planning reform. I'm really pleased with the way it's working, and members of that board come up to me as individuals when I pass them in the street and tell me how pleased they are, and how relieved, the progress.
Well, I've got one more question on the partnership board. I think Deputy War has one on the board as well. But your example on design is an interesting one. How have you found the relationships within the industry between those who are more design-led, such as architects and interior designers, and those who are kind of plan or client-led for maybe achieving kind of plans, which would be a planner? How are you finding the board brings together those who have those different
Everybody
skills?
around the table are professional people. They may represent slightly different parts of the same industry. They all have to work together, and I think when we start talking about design, there will always be an aspiration, excuse me, that the architects will be more focused on that. There will be, there will be the discussions around the amount of information required to fill in an application, more concentrated by some of the people who represent, clients who are putting in the application. So it's always a trade-off between everybody, but they all work together well.
Absolutely, Minister, and I'd probably just also add that architects and TAMBAs are chartered to institutes that have codes of conduct. So irrespective of whether you're working for the government or for a client, your professional advice is, like I said, part of your code of conduct.
I'll be clear, I was not questioning in any way the integrity or professionalism, but it's a very important question, not in a critique, but to understand the nuance as to how client relationships between their professional services act. And it's a good, I think it's a point we can discuss without in any way infringing kind of the professionalism of individuals. It's more about that relationship between people. So a client will have an architect, a client may have a planner, a professional planner, I should say, not a department is where I was highlighting. And it's their relationships between independent planners and the clients. It wasn't to do with your department.
No, absolutely. The same for independent planners. They have chartered institutes. They are held by code of conduct as well. The professional planners on the island, as I said, are registered chartered planners for RTPI, and they would have adhere to their own code of conduct.
The important thing about the partnership board is the word partnership, and certainly it's been constituted and put together so that all different parts, all facets of the construction industry are there sitting around the table with people who represent the department, looking at the challenges and seeing how we can work together to make things easier, make things better, and make everybody happier. And I think so far it's worked quite well. And there will be challenges. There's certainly never any arguments. I mean, people challenge each other, and you'd expect that. But it works. I'm really pleased with the way it's working.
Deputy Wall?
Yeah, sure. This is going to be a bit of a sort of slightly red herring in terms of where we're going with this one. But I mean, I was really interested because red tape is my bugbear right now, and I think we obviously at this moment in time next week we're going to see a proposition brought forward in terms of meanwhile use, and what I'm really interested in is. What's been interesting has been the history of meanwhile use in terms of, I've been quoted here, Jersey Development Company have turned down meanwhile use, Marquees and the Weybridge have been turned down for meanwhile use. Isn't the purpose of planning to be sort of economically positive, to take a positive view of applications And what I'm being very struck by is a complete misunderstanding of meanwhile use and how we become more productive. And so how can the...
Could I ask, could we address that at the end of this section?
Yeah.
Okay.
Because we're moving
Okay,
through, and that
okay,
might be
okay.
planning services
Fine. Okay.
improvement, but that's slightly off where we're
Okay,
going.
sorry, I appreciate that.
That's great. So I did want to move straight on to part of the improvement in the planning services and looking at Project Reader and understand the current implementation of that.
Okay, well, before Kelly gives you the detail, Project Reader's been on the go for quite a while, and there's been a few delays. But I will hold my hand up and say I am as responsible for that as anybody, because I have told Kelly that I want the programme tested to destruction before it goes out, and I'm much happier to stand up and take flak as a minister for another month or 2 months or 3 months of delay, rather than have the project go live and find that we have got some issues. It's a big piece of work, and officers at the moment are testing it, and we're getting closer.
Absolutely,
but
yes.
It's the autumn. It's going to be the autumn.
Touching all the wood, we're hoping for August, a go live in August. So yes, it is we're just about to go to end-to-end user acceptance testing. The system is 99% in terms of development done. There's a few tweaks finally to go. We are focusing on the data migration points. I am absolutely delighted, actually, at the progress to be able to take such a transformational program and to be able to say to you, we are literally on the cusp. So once we have tested it to destruction with all the connections in place, I said hopefully in August we will have a go live.
You'll be pleased to hear this, and I'm sure you know it, but it's going to give us the ability to interrogate stuff so much better, get information out of the system. We've got masses of data, which we should be doing better with.
Okay, and then as part of planning service improvement, what is your next focus?
I'm trying to think.
Minister, we do have a consultation coming out shortly.
We are doing GDO because we're going out to 2 phases of GDO. The first bit is going to be permitted development, straightforward questions. You know, what do you think about having larger extension in your back garden with a whole load of stuff? Second part of the GDO review is going to be a bit more conceptual. You know, how do you feel about allowing an extension on the back of the house with GDO to be 2 stories high instead of 1, that sort of thing. So, and there's, I think to be fair to officers, they've come up with some quite challenging subjects.
Absolutely.
And
We'll
they
be
really have
consultation
to chuck the kitchen sink at it.
They were also picking up, so there's sort of 4 areas of the planning reform. So the rules, which is around the controls, planning controls, codes of conducts, the building standards review, obviously, and bridging on plan interpretation. The people, so ensuring we're investing in our teams in terms of the industry engagement, leadership, growing our own, so the investment and sort of master's degrees in planning for our own internal teams.
Appeals, we're looking at 10 years since we introduced a new appeal system, so we're looking back at that, seeing how that's working. We know we've got some areas where people don't have appeal rights, where they should have.
Looking at the planning obligation agreements and the planning committee procedures, looking at minor application review and sort of just early interventions as well between planning and building when commencement starts. There's quite a number of areas that we're picking up on as well.
And are you doing them individually or kind of all together, and would we be seeing changes kind of
well, on the permitted development, when I get the responses to phase 1, which is very straightforward, I can do most of that by order, and I will do that straight away. The second phase of the GDO stuff is the more conceptual stuff. We'll go out to consultation, take people's views, and we'll act at that point. Some of it may need some law changes.
If it's a primary law change, then that might have a longer time scale, but the Minister is committed to making the faster changes through order in a shorter term. So it will depend on what the consultation responses say in terms of which direction that we go to.
And we've spoken about red tape this morning. I mean, this is to look at maybe reducing some red tape. It hopefully will result in less applications coming into the department for officers to deal with. But on the other hand, you've always got, considering permitted development changes, you've got to be really careful because you don't want to be the neighbour that lives next door to somebody who's just had permitted development rights and built something which has a great effect
Which
on
would be
you
lawful.
individually.
So you just for more for the anybody listening at home and transcript, you've used a GDO acronym. Can you just explain what the GDO?
General Development Order.
Permitted
And
development rights.
permitted development, I think, is what we're talking about. Yes, I apologise, acronym overload. But no, permitted development.
Thank you. Deputy, questions?
Okay, and lastly, one part of the your review we understood was to be at how one builds and ultimately reshapes island plans, and I think you noted obviously the inflexibility in terms. Has anything shaped in your mind as to what you're looking to bring forward with regards to how an island plan is formed and shaped and ultimately lives?
Okay, I'll make this as quick as I can. I am in the camp very firmly that believes that the island plan process that we have at the moment has served us well. We have a planning-led plan, or plan-led planning system, and I think that's done really well. There are options, and we're going out to consultation to see how people might feel about treating that differently, and I'll be interested to see responses. The next government will have very soon after they're elected have to make some really crucial decisions about the next island plan. Bridging Island plan was there for a short period of time. I'm not going to go on the reason why it's still valid, but population hasn't increased, so housing demand is not. We don't need to rezone too many more sites. The law says quite clearly Bridging Island plan can stay in place until another plan is needed, and so we use it. I can't see any reason why we can't continue to use it for the short term. I would think the next island plan debate will be 27-28. It's a very, very expensive exercise. It was £1 million to do the last one. And I think government may well need to have a think about whether they want to commit another £1 million or million and however much it's going to be. But just the examination in public is a big six-figure sum. We do have the option to think about maybe a twin plan system. We have allowed an overriding plan with a more detailed plan underneath, which you renew on a more regular basis. Certainly, I think that's the way they do it in Guernsey. It's a system adopted by some councils in the UK. It's worth looking at. I think we may find that we are challenged financially by the cost of an island plan, a full island plan review. Next time, I'm not going to be here. Well, I may.
Specifically, so we will be giving you more detailed questions in 2 weeks' time. I
wish I could say I was looking forward to it.
But now turning to the last section, which unfortunately we have.
Can I just finish that quick because
yes.
you didn't answer the question earlier? We were saying we were going to leave it to the last
sorry.
bit around
Deputy
about
Ward, sorry.
the meanwhile use proposition and I talk about red tape and meanwhile use being red tape light, as it were, is something you can do fairly rapidly to make sure we get more productive use out of our built environment. Thoughts around that? Because I think there's a lot of misunderstanding.
I'm always in favour of taking opportunities where they present themselves, but I think we just need to be really conscious that we don't compromise ourselves and set precedents for other things. I think you mentioned the tent in down the Liberation Square.
Yes,
Liberation Place. I fail to see how something can be left in place for such a long period of time. Without some sort of an application. That did confuse me somewhat. I went back to officers a number of occasions saying, hang on a second, that can't be temporary. It's been there forever. You worry about setting a precedent for something being in place 8 months, 9 months every year or a bit longer, and then before you know it's 2 or 3 years that's happened, and then you know where we are. We haven't. But meanwhile use, I can't dispute that a good meanwhile use opportunity shouldn't be taken. If you know something's coming down the line, you've got 2, 3, 4, 5 years before it happens. I mean, I walk past Le Sablon every day. Maybe I shouldn't say this, and I look at that site and think, wouldn't it be nice to put a couple of benches in there, flatten a bit off, and let some members of the public sit on it until the developer decides when he's moving forward. But it's not my land. If it was public land, I certainly think we would be trying to do something with it.
So you're
Only
positive about that idea?
To make a point of clarification, I think that the marquee in the Weybridge did have a fixed term planning permission in place. So
Okay.
Did it?
yes, it did.
Oh,
Yes.
okay.
And it is now no longer there.
Thank you. So,
Thank
okay,
you.
yes,
And
move on to...
moving on
yeah,
the last
to
section.
the marine section.
Marine sector.
Sure. So can you confirm that the framework and implementation timetable for the marines...
Oh, there's our resident expert is
Just come online. Okay,
sending
I'll kick off again. So can you confirm that the framework and implementation timetables for the Marine Spatial Plan was published as anticipated in May and direct the panel to where this has been published?
The Marine Spatial Plan timeline, are you specifically talking about the marine protected areas?
No, specifically when we discussed the Marine Spatial Plan, and it was a recommendation from an amendment from the panel to say that we needed a framework and timetable to understand all the areas of
Okay, I'm going to go to Francis for the framework and timetable, please, on where we are with the MSP.
Afternoon, Scrutiny. Good afternoon, Minister. It's ready to go. There were some questions around the impacts of the sand eel arbitration that were going on in the UK and how that might impact the outcomes of our next piece of work on this. So the Minister was advised by officers to hold off while we saw what the outcome of the sand eel arbitration was. We're now through that, and we've got the assessment from it, and we're looking to re-present the timeline documents and the MPA detail documents to the Minister on Friday this week.
And when you're talking about, what do you mean? Could you give a bit more explanation about that stand-in arbitration? Is that what you meant?
So the UK protected in England and Scotland several large areas as MPAs over last winter, and the European Commission took them to arbitration. It was the first case of arbitration around MPA areas since Brexit, and the outcome of that case was will set the tone for the implementation of future MPAs. Now, it went mostly on the side of the UK, but not entirely. So we've taken the learnings from that, and we're just building that into our messaging, how we look to describe proportionality and other key factors that were addressed in that.
It's important that we get anything we do 100% right, because as what Francis hasn't said is the cost of that arbitration ran into many millions of pounds, and we've been told very clearly if we ended up in arbitration ourselves here in Jersey, we would be looking to find that money, which we'd rather not do, so we'd prefer to get it right first time.
Yes, it's an interesting situation where you have, an agreement at an international level that is then agreed within the EU as well to meet certain MPA things, and then to be able to then take different jurisdictions to court over something that is agreed internationally is an interesting situation to be in.
Well, I'm not passing comment on that. I'm just making sure that I don't find myself as the subject of an arbitration, because it's expensive enough in Jersey. But if we start going to international arbitration, I'll be looking for another job, I suspect.
Yeah, sure. So, do you want me to ask this one?
Yes, please.
Yes, okay, fine, sure. So please could you provide the panel with more detail on the benefits of Jersey's fishing community of the extension to Jersey of the International Convention for the Conservation of Atlantic Tuna?
Okay, so we've put a huge amount of work in for the last 4.5 years doing the putting all the data together to submit to the UK. And in order for us to sign up to ICAT, as you just used that, I won't go through those long words again. In order to sign up, we have to prove to the UK. UK are the signatories, and we now come in under them. So we've had everything is now done, and we're literally just waiting for the last signature in the UK. But to all intents and purposes, we're signed up. That has allowed me to indicate that I will allow a catch and release fishery for the months of August, September, October this year. I've agreed the criteria earlier this week about what we would require if people want to go and do this. I'm prepared to issue up to 5 licences to do catch and release. My hope very much next year will be that we will, through the UK, be allocated a small amount of quota to not only catch and release, but to catch and land. And I will be working very hard with officers to make sure that we get the maximum economic benefit from that. Tuna, catching tuna and landing it in a way that is top quality meat is difficult and challenging, but it can be done. And if the fishermen follow all the rules and regulations, we could have some very high quality fresh Jersey tuna in restaurants and hotels next summer. But we need to be really careful about how we do that. We need to work really hard with the industry. But going back to your original question, hopefully there's an opportunity for a catch and release fishery, which would attract tourists and locals to go out and do that. And my hope is next year that we will have a small amount of quota which will allow fishermen within our commercial fleet to diversify if they can meet the strict criteria that we're going to put in, because we do need to do things properly, but there are opportunities.
Minister, the 5 licences for the catch and release, will they be Jersey local licences?
Yes. 2 of the immediate prerequisites are you have to have your boat has to be commercially coded to take paying passengers, and it also has to have a J number on the front, which is a fishing permit. So that's an absolute starter for 10, and there will be other things which follow in as well. Catch and release is what it says, and it would involve some equipment which allows you to land the fish into the boat really quickly so you don't tire it out, how you treat it on board and how you get it back into the water. We want a little bit of data from it before it goes back, but the whole idea of catch and release is for the fish to get back into the water in a fit state to swim off and enjoy the rest of its life. So,
and how will you be enforcing this, like, to make sure that this...
Well, training will be given, and there will be a requirement on top of some of the things that I've said, like the JCAT, like the coded vessel, the equipment on board. But we will, I imagine I will be wanting to see some sort of a business plan which demonstrates that the people who are doing this have an experience of fishing and catching fish, returning them to the water. And officers as well will be keen to be making sure by spot checks and stuff like that, that everybody's applying by the rules. I'm really keen that we're not going to mess this up in the first year or 2 by not getting things right. So as a team, we will be working hard to make sure that happens.
So I just want to pick out, you've given a whole series of answers here. So one question comes to mind here is, how will the decision to expand fishing rights from catch and release to commercial fishing of North Atlantic bluefin tuna be made? Will it be made by the States Assembly, or will it be a ministerial decision?
I believe it's a ministerial decision. Certainly it's our intention, as I said, to apply for a part of the UK quota next year. We would be given a small chunk of the UK quota. And we think we'll make a case. Do you want to add something to that, Francis, please?
The only thing to mention is that obviously we'll need to take it off the wildlife law listing, which is where it was put when they first started appearing on our waters and we didn't have any scientific data from them. We now know a lot more about the species both in Jersey waters and through their whole life cycle that runs from the Mediterranean to the south coast of Norway. So we've got that confidence to take them off the wildlife law, bring them into a very, very closely managed fishery. And the fishermen who are interested in doing this are really interested in getting it right. They're not there to have a quick punt and make a quick buck. They really want this to be a part of a long-term, economically and ecologically sustainable fishery for them.
And when this expansion to the commercial section, and it's interesting, thank you, Francis, for talking about that scientific data, because of course we're seeing that, the new minister had said that there needed to be much more research done to help expand the MPAs. When we were talking about the marine protected areas, and I wanted to make sure that we feel that we have the scientific data to the level that we know that we should be able to move from catch and release to commercial so quickly, and it was just wondering why you were doing that so quickly.
Well, I mean,
from
I
one
have
to
to
another.
say, as I said, we've spent 4.5 years accumulating the data. I don't think we necessarily need any additional data to move from catch and release to catch and land. It's just that the way things developed this year, we didn't have the signatories and the agreements in place early enough to be awarded any quota for 2025.
Okay.
I do have it within my powers to move forward, as Francis said, we are treating it under, working with exemptions in the wildlife law for this year. But next year, when we're positioned right at the beginning of the year to put our application in for quota, we will do. We weren't quite ready this year, so we weren't in a position to apply for quota.
And will their catch and release continue? So you would then have not only the 5 licences for catch and release, but then also on top of that commercial. So in a sense, you're expanding.
We have, yes, it will continue because I'm hoping that we can develop that as an industry. The amount of quota we will get, if we get any, will be quite limited. We will have to restrict us more to a number of vessels and a number of fish or a number of kilos over the course of the season, which is relatively short. But we, as Francis says, we want to make this work. We want to expand it as much as we can so as many people can benefit. And that will mean not only commercial, but it will mean recreational as well. So we will move forward in steady steps at every point, making sure we've got the management 100% right.
Okay. Final question then. Sorry, did you?
Well,
Yes.
just to confirm, you've been adamant that it's the catch and release and commercial is related to the Jersey fishing fleet only. There's no mechanism whereby other fishing fleets can.
No, absolutely not. I've been very firm on a number of occasions over this sort of thing, and in this particular case, as we've said, it can only be a J boat, which means it's got to have a Jersey fishing permit / licence. In this case, you're going to have paying passengers on board, so the vessel has to be coded to be able to do that, and there will be other restrictions, requirements that we will put in place. But I've been very clear. We have over the last 10 years, charter fishing in Jersey waters can only be done by J registered boats, registered fishing boats. And the reason for that was very specific. We did not want a large number of boats arriving here from the south coast of England to enjoy and exploit our fish in Jersey's territorial waters. So we're very clear about that. And that's the reason why we start from that premise.
And are we extending that to commercial? When it becomes commercial, it would just be Jersey licensed
yes, absolutely,
as well.
It would be
no
under strict management. The first thing is you've got to have a J licence. I mean, it would be a big decision for us to go away from that. I don't know if the Assistant Minister has got plenty of experience, but it's a good way of starting.
Well, we've got a good framework in place already to manage the vessels, so it would seem silly not to take advantage of it.
Last question. Yeah. Okay, so final question. So can you provide any direction provided to government so far from the meetings of the Natural Environment Ramsar Working Group? So what recommendations made by the group have been acted upon?
Well, we have a new chair who I was pleased to welcome at Howard Davis Farm quite recently. We sat down and spoke at length about Ramsar and how we're going to move forward with that. The big changes that we have had in recent months is that the management, or the management, if you like, has now been taken over by the department and officers in the department who are going to go on site and do the work, which previously had sort of been entrusted to volunteers and stuff. So the Ramsar committee, the Ramsar group, will continue to be their representatives from across the board. But the work that they decide to do, or the work that they would like to be done, is then entrusted to officers at the department. I don't know if you want to add anything, Francis, but we have a lead. We have an officer in Marine Resources that's now the conduit and has a big part to play in the administration and help in Ramsar.
Certainly. I mean, there's the Jersey Ramsar Advisory Group, as you said, Minister, who are our critical friend outside of government and keep us on the straight and narrow on Ramsar delivery. And then the Ramsar Management Authority, which is made up of civil servants from across environment and wider. And they're the ones with the job of setting out the management plan, setting the research plan, and then delivering against that. Mostly with government officers, but also in partnership with key external experts who very kindly volunteer their time for a love of the Ramsar site on the whole. So we've got Ian Buxton and the likes who are very kindly helping us with bird counts and all sorts of things like that. So best quality research hopefully going in there.
The only thing I would add, that we did discuss amongst other things, a potential extension to Ramsar boundaries. We are conscious that when we start the work on the seawall in the Haverday Power area to try to protect the area from flooding, that work will all happen on in a Ramsar site, so we will have to have some of the Ramsar site to work on. I'm considering the possibility of maybe reducing the size of the Ramsar site to Haverday Power and increasing it significantly more in the area north of Gorey, between Gorey and St Catherine's, as a trade-off, if you like. We spoke about that. We didn't reach any conclusions, but that's certainly something I'm considering.
We'll definitely come back to you on that, Minister. And I just want to circle back with my last question, something around the marine spatial plan. And I understand that, you know, this timeline will be coming imminently and discussion will happen on Friday. But there is also waiting for the full economic impact assessment. That was also we were waiting for and wondering when that will be available.
Well, it'll have to come before I make my final decision, because the whole reason for doing it was to make sure that I didn't make a decision that had a major economic impact, which I hadn't considered. But Francis, I'm sure, is going to tell us more.
Thank you, Minister. So we're working with the Economy Department, who have chartered economists. They are conducting the economic impact assessment, and the Scots agreed to peer review for us. They published the first and most well-cited marine economic impact assessment. So they're bringing in their team to give us advice, guidance and peer review on the final EIA, so that we'll have a strong and robust position come the autumn.
And so, final then, when will we hear the timeline? When will we hear about our MPAs?
I'll be looking at the timeline at the end of this week. I'm conscious that the specific timeline for marine protected areas is something I need to issue as well. I am conscious of scalloping seasons, closed periods of time and stuff like that. But the team are in the moment conducting the last pieces of research on the areas I've asked for further information on. And I can't really say more than that, but as soon as that data is available to me, I will be making some decisions, and those decisions will be around which areas I'm changing, when the areas that are already agreed and not going to be changed, when they come into play, and how long I give the areas which I've grandfathered for some specific reasons, and all that will be set out in the not too distant future.
Well, thank you, Minister, and I hope when we meet you next in the next full quarterly hearing, we'll be able to have some clear dates for a number of those areas we've covered today. There's lots of work to happen before the end of the year and before our next quarterly hearing, but thank you very much to you, to Assistant Minister and to officers here in the room and online for helping to support answering